Okay, and I'm gonna call the meeting to order at 1:06, and I'll take roll. We have Judge Hall here, myself, Laurel, Mark, Thad, Carol, Deirdre, Dr. Andaya, Jeff, and Geraldine. So we have reached quorum. Gonna ask if anyone has to disclose that there's anybody 18 or older with them. Seeing no disclosures. Brandon, do we have any public testimony on this?
No hands raised.
Okay, great. So we can get to our agenda item B, our action items. So we'll be deliberating and hopefully making some decisions today about the final reports from our permitted action group. So we'll start with B1A, the assisted reproduction and surrogacy pig. So we'll open to discussion.
Before we do that, Sean just sent me a text saying he joined the public link.
Oh,
there
Sean,
we
I think oh, there you are.
There I
Okay.
am.
Sorry
Hi,
about
guys.
that. Okay. Hi,
Thank
Sean.
you. Bye.
okay, so any comments, any discussion?
I'm sorry, Sienna. That was my group, right? That you just said. I was distracted by Sean's text. That's what you said, right?
Yes,
Okay.
yes, it's a reproduction.
Okay. Well, I believe that I didn't remember hearing any like any objections to our PIGS recommendations as revised in our final report. We did discuss at multiple different times over the last few meetings all of the changes that we were suggesting, and it is very much largely sticking with the Uniform Parentage Act. So I'd be happy to answer any questions, but I don't think that it's necessary to go over all the points again, since we've done it several times. And then I'm gonna defer to my other PIG members for anything that we're missing. Where's Dr. Fraterelli? He's not here today.
Any comments, questions?
Sienna, I have a couple of questions, but
Sure.
they're more about process, so
Okay.
maybe we should wait and see if there's any subject matter.
Yeah, any subject matter comments, questions? Okay. No, Laura?
Okay. I just wondered during the deliberations on the art and surrogacy provisions, if you all talked at all about increased regulation in the industry or the practice. Was that something that ever came up? It's just a question. It can be a yes or no.
I'm not sure I understand, like regulating who?
Well, that's the question. I think are these they could be considered, in my opinion, a little bit regulatory on the practice of the industry. So, but if you didn't address it, that's fine. It's just a yes or no question.
Well, I think it was basically like there is a degree of regulation that is within our PIGS proposal and proposed edits, which is mostly in keeping with the Uniform Parentage Act, but I don't recall discussing it from exactly the angle that you're asking for.
Okay. No,
but I'm
that's
not
fine.
sure if that answers your
Yeah,
question.
it does.
It's intended to regulate, right? I mean, it's intended to regulate and guide
Right.
in this area of the law.
Right. Okay.
Yeah.
And then I just wondered from the draft that had been posted last fall, I think Judge Hall had offered a draft for us to work from. Was there any discussion of Part 10 in that draft?
Part 10. What was that addressing?
It's called information about donor.
Oh, no, our PIG understood ourselves to be addressing just the assisted reproduction and surrogacy portions of the bill as we received it from Judge Hall
Okay.
quite a while ago. Yeah.
Okay. Thank you. That's all.
Are there any, does the task force feel like it's ready to make a decision or entertain a motion to accept the policy recommendations and revisions reflected in the assisted reproduction permitted action groups report, final report.
So moved. Can I get a
Second.
second? All right, thank you, Judge.
All right, all in favor, please raise your hand.
Oh, Carol's doing the Zoom hand raise. Are we
Yeah,
supposed to do
if you
that?
could do if you could do the Zoom hand raise, so
Oh,
like,
okay, okay,
a little easier
there,
to see.
okay. Did I do it? Okay, sorry.
So we have,
Except Laurel. Laurel doesn't have to do the Zoom hand raise.
Right, yeah, because she could use her actual hand.
we have Carol, yes, Thad, yes, Sean, yes, Deirdre, yes, Judge Hall, yes, Mark, yes, Dr. Andaya, yes, Geraldine, yes, me, yes. We have 1, 2, 3. Deirdre, did you mean to have yes?
Yeah, don't I? Isn't it there?
No, it came off.
It did. I didn't mean to do that. Of course I'm voting in favor of it. That was my motion.
That was, all right. So we
I'm
have
not that disorganized. I'm sorry.
me,
Thank you for clarifying.
yes, 1, 2, 3, 4, 5, 6, 7, 8, 9. So with 9 votes, yes, the motion passes. All opposed.
What
Oh,
happened to Sean? Oh, no, there he is. Okay, never mind.
It moves around when
Yeah,
the,
you gotta take your hand down if you're not voting no. Because Sean and Jerry voted yes, right? So their hands are not counting for no.
Jerry, put your hand down.
okay.
No, put the,
Didn't
your
count.
Zoom hand down.
What did Jeff vote? 'Cause
Uh,
now I'm
Going
confused.
well.
so now I'll take any votes in opposition.
Is there Kanalua?
Are there any are there
Can we
oppositions?
abstain?
Yeah, I was gonna,
Are we allowed to do that?
are there any abstentions?
I'd prefer to abstain.
Okay, so we have Jeff and Laurel abstaining from the vote, right? But with 9 votes yes, the motion passes. Okay, so we will pass that on to the drafting pig once it's created. All right, so let's move on to the legal parentage pig. So we had some discussion about the final report being very dense. And there were some questions about the Uniform Parentage Act's de facto parentage process that was already in the UPA, and kind of how the pig may have considered that and how that might have achieved some of the, Dr. Frederelli just joined, how that might achieve some of the goals that the legal parentage pig had. So I'll open it up to the floor to individual task force members to discuss kind of what they think about the de facto parentage provisions and kind of how they react with our kind of the proposed goals. Sean?
I'm unmuting, I'm lowering my hand. Yeah, and I had some questions about this maybe 2 meetings ago. I think after Judge Hall had dropped off, I apologize. I wish I had been at the last meeting. As I know there was a lot of discussion, but I know that the questions I had at the time were around, I think it was the professed parent. I believe that's still the term we're talking about, right? But sort of what kind of process would, like, what sort of process would there be if, you know, if this sort of procedure was used, how would we ensure kind of that, is it similar to adoption, where there'd be like publication, like how do we ensure that there's sort of the rights of potential fathers out there would be kind of addressed? And I think that's basically how I can frame it now. I think this might be just directed to Judge Hall, but anybody else as well.
Judge Hall, did you want to?
Yeah, if I could jump to first, at the last meeting, Courtney Jocelyn from the Uniform Laws Commission brought up the question regarding de facto and does it actually cover what professed parent we were trying to do in professed parent. And I want to apologize to the group because I did go back and she is correct. De facto does essentially do, the de facto language does essentially do what we were trying to do in the professed parent. My brain is locked on how the law is now with de facto. where you can only get custody. You cannot get your name on a birth certificate. You only can try to go for rights of custody. So after I looked at it again, I did talk to Courtney to clarify a couple things. I do think the language of the de facto that's in there now for de facto parent would suffice of what we were trying to do with professed parent, but in our PIG, we did have a discussion about maybe not using the term de facto parent, because in 571-46, it does have a de facto parent language about getting custody. And if we use the same term, it could be confusing. So we were thinking of using a different term, and I'm sorry, Sienna, I forget what the name of that, what the term was. I think it was functional parent.
Functional, I think functional parent.
Yeah, functional parent is what we're looking at. Still using the same language in the de facto parent, just changing the term from de facto to functional, and getting rid of professed parent completely, what we are writing up for professed parent completely. And then with regards to Sean's question, we would require the birthing parent to attest under oath that they don't know who the father is and reasons why they don't need the father. They don't know who the father is. They're going to have to give us a basis as to why they don't know the father before we'll make the finding that they just really don't.
Okay.
And then to clarify, Judge, you know, there's a process, correct, for if there was a parent who may not have their rights recognized to try to challenge some.
Oh, yes. I mean,
right, like
anything with children, it's always open. It's never a completely shut door. So even if we were to find parentage with somebody else, but the true biological parent discovers down the road that they are the biological parent, they can come back and reopen it to argue for their rights to be established. So the door is never completely closed.
Deirdre?
Oh, thank you. Judge Hall, I had a follow-up question based on what you just said, that there was an existing provision in chapter 571 about de facto parents. You still see utility in keeping that separate provision, which I'm assuming you're saying that because it would not be repealed, right, by this bill if enacted. And then you would
Right.
have the new functional, the de facto by another name, right? So you would keep the provisions for de facto parent, but give them another name, but you see that there's still separate utility for those avenues, maybe?
Yes, because the
Yeah.
571-46, it's actually A2.
Yeah.
It also applies for divorce cases. So
Mm.
I don't want to get rid of it completely because it could apply for divorce cases, unlike our UPA statute would not apply to divorce cases.
I see. Okay, so that would mean there would be a method by which a adult who had served in the role of a parent could establish a right to custody in a divorce proceeding, even if they had no legal or biological tie to the child. But they had
Correct, but they
done
wouldn't be
the
able to go
emotional
on the
work,
birth certificate.
They wouldn't be on the
Right.
birth certificate, right? But it might give them custody. Is that's what you're saying?
Right, so
Okay.
let's say a stepfather has raised the child since they're 2 years old, the child's now 14, and that's the only father that child's ever known. He may want to step up and say, hey, I'm the dad. I've been the dad all this time. I want to continue to be the dad.
Right. Oh, we lost your sound for a minute there, Judge.
Oh, I was just saying that it would 571-46 would allow somebody to be able to step in and say, I want to be the dad still and still have custody rights, although I recognize biologically and as a legal parent, I am not the legal parent, but I can be a custodial parent.
That totally answers my question. I just wanted to make sure that if we were doing the word functional to replace what appears as de facto in the Uniform Parentage Act, that those two distinct things meant something different, and they clearly do. So thank you. That's very helpful.
Can I ask a quick, sorry. I guess Judge Hall, so you know me, I kind of just want to protect Hanai, so we're okay with Hanai, right? This isn't gonna, will it help it? I just want to make sure it's not gonna hurt it, but.
Oh, absolutely. I would never want to hurt Hannah either.
No,
I
know you
truly
wouldn't.
believe in
No,
that
I know you
too.
wouldn't. But I just want to make sure. Okay, thank you.
So I think that there are some differences between the professed parentage kind of process that was proposed and the de facto parentage that's in the UPA, which is also currently in the draft bill that we are looking at. So I was considering a couple of changes to allow for the de facto or what we would call the functional parentage process to make this process available at birth, because that was one of the issues that we were attempting to address with my understanding that we were attempting to address with the professed parentage language that doesn't currently appear in the de facto parentage section as it's drafted. So if we were to consider moving away from professed parent and just continuing on with the what we would call functional parentage, that we would look at the language and try to see if we can make some changes so that it gave effect to kind of the policy choices that the legal parentage pig was trying to make. Yeah, Deirdre.
Has your pig had the chance to discuss that question yet?
So we can't, the pig cannot make a new report, right? If the pig makes a new report, then we have to postpone voting. So,
Right.
but the task force itself can discuss these things.
Oh, I see. Okay.
Right, so this is, this is some of the consideration that we might want to have, or this is the discussion we're opening up here. That
Okay.
there
Okay.
are some changes to what we would call the functional parentage process that we could make that would address some of the issues that we were trying to do with professed parent, but stay within kind of the UPA's drafted process. And that would simply be some small changes that allow for a more immediate process at the child's birth, because currently the de facto parentage process requires showing significant time spent with the child. And
Mhm.
if the child's just been born, you can't show that.
Right, and when you say de facto, you mean in the
The
bill,
de
not in
facto,
the current law, okay?
yeah,
So I would just like to know what Judge Hall thinks of that. Would that change serve the policy goal that your pig was looking to address previously?
It would actually, and stop me if we're not allowed to decide, I mean, something that's a possibility is requiring the two that are looking to be like the birth parent as well as the other person looking to be named as the functional parent would have to establish that they've been in a relationship for a set period of time, that they've had this intent to hold themselves out as a family and have this child as part of their family together. That would have to occur before the child's birth. And personally, I was thinking something like 18 months. So that would allow the whole period of the pregnancy. So it's not just somebody coming in the middle of a pregnancy saying, oh, I want to be the parent of this child. It's somebody that was in the relationship with the birthing parent that wanted this child as well before the child was actually conceived.
And the benefit of adding that status for that hypothetical couple, that would be easier to use, or can be the major benefit is that they can take steps in that direction before the child is born. That's the difference, right? Because otherwise they have other avenues.
Well, they wouldn't necessarily take steps before the child is born.
Right.
But as soon as the child is born, they could take steps versus having to wait a period of time to establish that relationship with the child that the current language, de facto language in the UPA requires.
Understood. Okay, so I would see it then using the word de facto to describe it as it exists in the bill, not in current law, that it would be basically a way to establish de facto parentage based on their behavior during the pregnancy and their relationship before it, as opposed to waiting for the child to be born and then starting the clock on a de
Correct.
facto parent. Okay. Thank you. That was helpful.
So with that, I think what it sounds like is that the task force may want to consider kind of taking parts of the legal parentage final report. For example, the policy recommendations and the driving force behind the changes and revisions that were proposed. And then to also maybe consider adopting kind of what's been recommended, which is to revise what exists as the de facto parentage process in the draft bill and revise it to reflect some of the policy considerations that have been expressed by the legal parentage PIG in their report.
And you think it's procedurally proper for us to do that now?
We can do that. So the task force can take action on its own as long as it's, discussing within itself during a public meeting, right? So
Oh, okay.
this
Okay.
wasn't a final report from the PIG. This is task force members bringing kind of changes that should be considered in light of the testimony from last.
Gotcha. Okay, gotcha.
So-
Well, I would like to make a motion then that we accept the recommendations of this PIG, subject to the adjustments discussed today, which would adopt the UPA version of de facto, but call it functional, and make adjustments in the policy directions adopted by the committee, by the PIG, as we just discussed, meaning to make it useful based on the relationship before the child is born.
I'm sorry to
that-
interrupt
Yeah.
to interrupt real quick. A member of the public just told me they have their hand raised. Are we allowing public comment on this at this
oh,
Yeah,
point?
no,
Yeah.
so yeah.
Okay, sorry. Go ahead. I just didn't know.
Thank you, Carol.
Sean, do you have a question? Can we hold it? We'll do the public testimony and then before we get to the vote, we'll.
I guess he's-
I can, I'm just, it's not really clear on what exactly the motion is, or if there's agreement on what's going on with the de facto provision. So,
Yeah, sure. Yeah, let's do public testimony and then we'll
Yeah.
come back to discussion. Yeah.
all right.
Brendan, we have some hands raised.
Oh, Courtney, maybe she can help.
Hi, Courtney.
Hi, thank
Give
you so
3
much.
minutes when
Thanks
you're
for
ready.
hearing me again. Yeah, I guess I also am trying to wrap my head around the kind of revised proposal that's on the table. So it sounds to me like Judge Hall is suggesting kind of merging the professed parent concept with the de facto parent concept, but I wasn't sure, Judge Hall, if you were suggesting that under this new functional parent provision, everyone would have to show that they were in a relationship with the birth parent for 18 months prior to the birth of the child. Because if that is true, then it's somewhat inconsistent with what we wanted to do as a drafting committee with this provision. We very much wanted this provision to be available for people who might come into a child's life after the child's birth, like a step parent or a family member who might end up parenting the child because the child's parents are not able to care for the child. So I wasn't sure what you were suggesting, and I wanted to flag that potential concern.
I was actually thinking more, it would be a either or.
Oh, okay.
Either you show the relationship before the child's born, in which case, as soon as the child's born, you could go ahead and proceed with determining parentage, or you could still do the 2 years and have that option as well.
That's helpful. Thank you for clarifying.
Anything else? Courtney?
No, that's it. That was my question. Thank you.
Great. Yeah, thank you. Brendan, you can. Go back
Thank
to
you.
meeting room. All right, Sean?
So based on that, so the either or concept is it that sort of the factual predicates, the tests that you have to satisfy would it be sort of the same facts that are in the UPA, the 2017 UPA, and then also in addition to that, the or would be what you wrote up for professed parent, basically? Is that essentially what we're talking about? So one of those two things gets you into functional parent. territory? Is
It's
that
not exactly what was written up for professed parent, but the concept, yes.
okay? So it's not what I mean. What is that? What does that mean? Not exactly. So
Well, our professed parent didn't have where you had to establish a relationship 18 months prior to the child's birth, and it didn't have all of that language in there.
okay.
Yeah, Jerry?
Yes, I just needed to clarify, Judge Hall. So, with regard to the proposal, this applies to the judicial setting, specifically, yes?
Correct.
Yes, thank you. And I do have, another issue with the, voluntary establishment of parentage. And that's a separate issue, but, I'll wait until we're complete in terms of addressing Judge Hall's recommendation.
Okay, so I guess to clarify, I think the idea is that we would modify the de facto parentage process to make it more inclusive, because the entire professed parent process was to allow couples, non-hetero, non-cisgender couples, to establish parentage at birth. The de facto parentage doesn't quite allow that to happen. And so we're looking to change the language a little bit to reflect more of what we were looking to do, which is to create opportunities for couples, for people to establish parentage at birth. So the language would be changed slightly just so that we could include those kinds of scenarios, because currently it doesn't. And so as far as what the language would look like, that would be up to the drafting pig to start to propose language then that the task force could eventually look at before it finalizes it. But I think what our goal here today is to try to vote on policy choices so that the drafting pig can get started on kind of compiling everything and moving forward. Jerry, do you still?
Yes, I would, with regard to the voluntary establishment of parentage process, my recommendation is intended parent be included as an area that would be addressed by the Department of Health, but not at the birthing center or with the midwives. I think looking at Part 8, assisted reproduction, which refers to the intended parent, there's a discussion of consent. And I believe that if you make it more complicated at the birthing center, it will only frustrate the birthing center staff and the midwives. It's probably better addressed at the Department of Health level.
And Jerry, those were concerns that you raised previously, correct? And that's what's reflected in the legal parentage's report.
I did raise concerns previously. I don't know if it was specifically that argument. I had indicated that that the expedited process should be simple and that it should not overburden the hospital staff or the midwives, because they are with the individual for a short period, whereas at the Department of Health, they can have probably a longer period in which to interact with the individuals wanting to have parentage established.
Okay, thanks, Jerry.
Thank you.
So is there more discussion on kind of this topic area, or can we kind of try to craft a motion based on the discussion here?
Hold on, are you talking about Jerry's comment just now or the topic previously about the
we can
functional
Keep
parent?
discussing Jerry's comment here. If anyone was present for kind of more of that discussion, if they could chime in.
To the
I just-
group, we already have carved out an exception. As far as my PIG group, for the expedited process of parentage, that is, we made an exception that as to a presumed parent, under two sections, that they may only submit their voluntary acknowledgement directly to the Department of Health. That is already a recommendation of the PIG group. I'm just saying, why don't we add the intended parent under Part 8 to that exception?
Is the intended
What?
parent, isn't that the ART? That's,
Are you suggesting a change to our section? Because we voted on that already.
No, it would be to the expedited process of parentage, strictly to the voluntary establishment of parentage process.
Okay, can you show me where you're looking in the bill? Like point me to the right attachment and what
Well,
page and what line?
If you look to the legal parentage permitted interaction groups proposed draft bill dated July 19th, 2024. If you
Okay.
look to page 20,
Hold on, I think I opened the wrong attachment. Hold on. This is.
So Jerry, the intended parent provision that you're section, correct?
pardon, I'm sorry, I didn't hear you clearly.
The intended parent provision that you're referring to is currently in the arts section, correct?
Yes, it's under Part 8, assisted
Okay,
reproduction.
but
That's
So
an
are you
intended
looking-
parent under the surrogacy agreement. That's what that's referring to.
Yes.
So
under
it's not
surrogate.
the same kind of parentage that's being established under these other sections that are from your PIG. Judge
Correct.
Hall, jump in if I'm getting this wrong. But
No,
like when
that's
somebody
absolutely
enters,
correct.
yeah, when somebody enters into a contract to do a surrogacy agreement, they're not yet a parent, but they're the intended parent of the child that would be generated through assisted reproduction and the surrogacy contract. That's not at all the same thing as these processes to establish parentage for a child who's already been conceived or has already been born.
And there's a separate process for the intended parent to have everything confirmed by the court prior to the child's birth. That would not make it necessary to include it as part of the VEP.
Oh, thank you
Correct.
very much. That would be very good. If we deleted the intended parent from the VEP process, that would simplify the process. And also, given the individuals who would have to process the intended parent situation, it would be less of a burden. Thank you very much.
But keep in mind, Jerry, the intended parent on the surrogacy section, they'll have an order that they can show hospitals or midwives that will allow them to sign any paperwork to be put on a birth certificate. So keep that in mind too.
Yeah, the phrase intended parent only refers to a child conceived by assisted reproduction. There isn't anyone else.
Yes, and the concern is the consent that the hospital staff would have to look at it. Or if the parent doesn't have it, but says, I have it. What does the hospital staff do? These are the kinds of questions that may be raised, that may
No, the
be,
parent would have to be able to show the paperwork that they have that already established them as the intended parent.
Right, and so if they don't do that, that's on them, is how I would interpret it, right?
I would
So
agree.
and
the burden isn't necessarily on like the hospital to disprove it, the parent has to come up with the paperwork, right? So they would have a surrogacy agreement, they might have a court order, depending on how they've handled it in advance of the child's birth, right?
And that is why I thought it'd be better to just have the responsibility with the Department of Health rather than at the medical center or the birthing center and the midwife, because you have such a short period in which the birthing parent is at that facility.
No,
And
but Jerry, when they get to the facility, they should have the paperwork already showing themselves as the intended parent.
I don't think they would even need to show anything at the hospital. If you look at the forms we attach for VEPs from Maine and Connecticut, they're filling out a declaration saying that they meet certain criteria. So they would be attesting that they have such an agreement, they've signed it, and that they're intending to be the parent. So I don't think they would even need to provide anything at the hospital. They would just be attesting to it. At least that's how it looks like in Maine and Connecticut. That's what the forms are doing.
well, the concern then is who then verifies that the information is accurate. And you had indicated, Mark, that the main form is just an attestation, but I think the Part 8 assisted reproduction is very clear that there be this consent, and it's a court order or surrogacy agreement. But if it's not there, I think at the medical center, the individual should not be allowed to sign the document.
Well,
There
if
has to be
they
proof.
can't prove it, then they won't, but you gotta keep in mind, I mean, we take people's word about this all the time. Right? Like we don't have a straight couple come in and say, yep, my husband is the dad. We don't do a genetic test on the kid, right? So the hospital is gonna have to take their word for it, and their word, and this is a same-sex couple, you know, who might be using assisted reproduction, is gonna be backed up by the paperwork. It's no different. We accept it.
I think actually, sorry, Deirdre, even a
Yeah.
more direct example is my boyfriend is the dad, because if the husband's the dad, you got presumed parentage by
Presumption,
statute.
right, yeah, but I mean, what
But
I'm,
she
what
can
I'm
come in and
meaning
claim
is
any
that we
boyfriend.
don't actually require like irrefutable proof. We accept people's word that they say that this is the relationship. And so I don't think we're asking for anything different. And I don't want to add an additional burden. I think people should be able to use whatever process is available to all parents, should also be available to the parents who conceive with assisted reproduction. Because what you're saying is, because of this additional burden, this additional level of proof, because a child was conceived by assisted reproduction, they can't do it at the hospital when everybody else can. And I don't want to do that. I want to leave it the way it is.
So basically, there is no, because of this extra step, this consent agreement, there is no verification. It's just a representation and an
Yeah, and so is the representation that the boyfriend is the dad. We don't require, like, we don't pull out a genetic test and make sure she's telling the truth, right?
Yeah, Jerry, so right now, there's no verification whatsoever that occurs currently. That process is not going to
Okay.
And the remedy would be if somebody signs that and it's fraudulent, then we could go back to court and have it reversed.
Exactly.
So
The
that would
dispute
be,
is
Yeah,
after
that
no,
the
would be
fact.
it
the
turns
remedy.
out she's
So-
lying, it's not the boyfriend, it's another guy. I mean, you have to make up these scenarios, right? And then it turns out that the actual biological father is a different man altogether than and it turns out they find that out somehow, or there's some kind of
That
showdown
happens
with all these
actually
people regularly, I
right.
imagine. And then
Yeah.
they can go into court and they'll use the genetic test when they need to, but we don't need to put up additional burdens for children, for the couples who are having children with assisted reproduction, just because that's a possibility. It's already a possibility for everyone. Right? People lie.
The one caveat on all that, but it applies to both straight couples and same-sex couples, people using assisted reproductive technology, is where it might catch somebody is they might sign on and then find themselves unable to get off in the absence of an alternative parent.
Mhm.
Right? That's
Right.
the risk
Oh,
they're
yes.
gonna take. But that's
Right.
always that's a risk for straight couples now. If boyfriend lets girlfriend new boyfriend lets girlfriend put him on the birth certificate, he's not getting off unless there's an alternative father listed right now.
That's true.
But that'll be the same that same-sex couples will be in the same position as current heterosexual couples in that regard.
Right, in terms of the easiness of signing the form when the baby's 1
Easy
day
to sign the
old.
form, very hard to get off unless you got someone else fighting to step into your shoes.
Okay.
Think hard before you sign that form.
Jerry, you should like that. More
Yes.
parents is good for the state.
Well, then it'll be less work to deal with that situation, because we know that they have the burden of finding someone in the wings and that person is willing to sign.
Right, so I
You
think.
you
at
are
the end-
correct.
yeah,
It's just,
at the end of the day, you're correct that there is this like interaction between these different portions of the bill. But I think that it's okay that we have to rely on people's representations, because it's no different than what we do now for everybody. So,
okay,
thank you, Jerry.
thank you.
Carol?
Sorry, just a real quick process question. If the drafting pig discovers a glaring inconsistency or a glaring error as they're doing it, we can still come back to the task force and say, okay, now we realize there's a problem, right? We're not stuck. So
Right, so
we don't
you
have to resolve everything perfectly right now in that sense, right?
Oh yeah, that will never happen. The bill is more
Yeah.
than 100 pages.
Yeah.
There we go.
So-
Yeah.
Yeah,
200.
the voting here today is really to accept kind of
positions.
the policy decision so
Yeah.
that the drafting pig has something to go on when, bringing everything
Perfect.
together and trying to finalize. So there might be nitpicky things, there may be, and that's why we're trying to do it as early as
Oh,
possible.
there definitely will be nitpicky things.
Yeah,
With
I
a
have to
100-page
assume
bill, the chance is 100%.
I have to assume there could even be a more significant policy thing that
There
arises that we
could
didn't
be,
contemplate. But
especially
we come
because
back to the task force.
yeah, the definitions have to run across the entire bill. There's like internal consistency issues that become a problem with such a big piece of legislation. So I think that's going to be the challenge, the primary challenge. If we have the major policy questions answered, like, if we're mostly sticking, like, for example, our section that we already voted on, we're mostly sticking with the UPA with refinements suggested by the PIG, then we implement those. It may turn out that when we actually put it all together, the puzzle pieces don't fit together, right? And so I'm anticipating that that's going to happen.
Yeah,
And-
so we just, go ahead, Judge. Or,
Oh, this
No.
is Jerry.
Oh, okay.
One other thing, and coming across and reading the proposed draft, I realized, and I did not realize it until it was brought to my attention by the Department of Health. They had a situation in one of the medical centers where there was a 14-year-old minor who wanted to sign the VEP along with a minor father. And there is provision in our current Uniform Parentage Act, 584-9B, which provides that the parent of the minor parent be notified, be it father or mother, or birthing parent or non-birthing parent, that the adult parent be notified so that there would be protections as to this minor. And given the age of the child, it's probably a situation where you have a statutory sexual assault situation, mandatory.
Jerry, if the two kids are close to each other in age, the law does not presume it's an assault.
Yes, well.
Yeah, if you
we
got a
don't know what the
50-year-old and
age-
a 14-year-old, then the law does lean in the direction of presuming assault. But two
14 and
15-year-olds
7
being foolish is probably not an assault.
Okay, 14 and 17-year-old.
Right, but there is a gap, there's an age gap built into the law.
Yeah.
Yeah.
So, I mean, and as far as signing, the adult parent of the non-custodial parent. As far as a non-custodial parent, until that parent reaches the age of 18, the adult, that parent of that minor parent will be responsible for supporting the baby. And that would be an interest of the adult parent to make sure that that child is indeed a child of their son.
Well,
Anyway, it is in our current HRS, and it, for some reason, it was not included, but I think it should be.
So Jerry, we're beyond the point of inviting a bunch of new things to be put into the report. We're at the point of voting for concept. So that
Yes.
way we can move on to drafting. So the final reports were already submitted. That was not submitted as part of the final report.
Yes, and unfortunately, it wasn't brought to my attention until just recently. And this is something that I had overlooked, so I'm
So-
just raising it now.
So I think we can put that, flag that as something as a consideration, and as Carol and everyone else has mentioned, we're going to come up with some things that might have been overlooked as we put these things together. I think what we want to focus on right now is the overarching policy concepts that we want to make sure get into the draft bill that guide us as we finalize the draft. So does anybody have any other comments on, at least as far as what the kind of overarching policy choices that the legal parentage PIG was proposing, Jeff?
I actually have a question, not on the topic, but on the process a little bit. The agenda wasn't totally clear to me about public testimony, and my understanding about public testimony is it was supposed to be in the beginning of any given agenda item so that it could be incorporated within the discussion. So it wasn't clear to me if there was public testimony that was to be allowed for any of these topics or not. That's just my question.
So we just had public testimony. Brendan, has any hands been raised in the interim?
Yes, one.
Okay,
Do you want to let them in?
sure.
Okay.
Good afternoon, everyone.
Hi, Jamie.
Hello. One thing I just want to flag that I want to make sure is taken into consideration when you are looking at the definition of what is now being called functional parent, was professed parent, that overlaps with de facto parent, is that it does not make possible the ability for a known donor to challenge parentage under the law. This is an issue that we have seen, particularly for same-sex couples across this country. And that threatens donor conceived people's right and ability to maintain a relationship with their raising family. And so anything that would potentially increase the ability for people to challenge that under this provision is of concern. The de facto parentage as drafted by the UPA sets pretty high standards, including a level of involvement with the child. And so just if we are lowering that level of involvement necessary, that we take into consideration the potential effects on known donors and their ability to seek parentage under this new law. Thank you guys so much for your time.
Thanks,
Thank
Jamie.
you.
Brendan, is that the only hand raised?
No other hands raised.
Okay.
Do we need a motion now?
Yeah, so if we could have, if there's any discussion that did anyone want to discuss the testimony that was just presented. I think that the changes that are being made still maintain a kind of a high requirement of showing that the parent is fully invested in the functional parent is fully invested in becoming a parent of the child. So I don't think that the changes that are proposed to kind of give effect to the policy choices that we're making kind of raise the concerns that Jamie is raising. Anybody else have any comments? John?
Can you just, I can't remember if the motion was stated earlier. Was that a summary of the motion? Could you just restate the motion?
No. So we've had a lot of discussion, and so we had to make sure that we stopped to do public testimony. So we should have a newly stated motion. I was not stating the motion. I was just trying to address our last piece of public
I
testimony.
think Deirdre took a shot at stating it.
Oh, nice job,
Can we hear it
Sean.
again? Sorry, Deirdre.
You're not sorry, don't
refocus,
pretend.
just to refocus
Just
on
to
what we're gonna vote for.
Okay, I'm gonna try again, all right? So I would make a motion to accept the recommendations of the legal parentage PIG with the adjustments discussed today, which would mean we would use the UPA version of de facto, but call it functional, and then follow the policy recommendations of this PIG to allow, in the alternative, a process for people to establish that at birth based on their behavior before the child's birth. Did I get it? Okay, Judge Hall gives me thumbs up. There's my motion.
No higher compliment than that.
Thank you.
I'll second it. How's
All right,
that?
I'll take Sean as the second. Okay, everyone in favor, please Zoom raise so I can take that to. I'll let them all come in first. Okay, so we've got Carol, Deirdre, Judge Hall, Thad, Sean, Mark, Dr. Federelli, Dr. Andaya, Geraldine, me, and Laurel.
Can I do reservations? Are we doing that?
Yeah.
I'm not really clear what we're voting on, but I'll vote so I can see how it's written up.
Okay, okay, so those are all in
pretty
favor.
confusing.
All right, you can please put your hands down. All those opposed to the current motion? Okay, any abstentions? Jeff, thanks, Jeff. All right, and the motion passes. And we will make it very clear what the motion was in our minutes. Okay. All right, moving on to our last PIG, which is the birth heritage PIG. Right. Thanks, Thad. Okay, we still have quorum. Okay. So let's do, the floor is open to discussion on the birth heritage PIG's final report and recommendations. Jeff?
Again, I just wanted to clarify, is this when public testimony is supposed to happen, or does it happen during our conversation?
I was gonna let the birth heritage PIG say anything, and then we'll have public testimony before we move on.
Okay, thanks.
I'll just start. Actually, I just wanted to again acknowledge all the work that went into this and the patience and understanding with the entire task force. I know it's been quite challenging. I wanted to actually let any members of the birth heritage PIG here go ahead. I have a statement I want to read, but I'd rather the other members maybe go first, if they wish to talk.
Jeff?
Yes, I do have another prepared statement.
Okay.
And good afternoon, everybody. I just came home yesterday from one of the most amazing experiences in my entire life. I was invited to special event which was held exclusively for 100 sets of identical twins from around the country. My identical twin brother from LA joined me, and we spent about 5 days at a variety of events, activities, and socializing with other identical twins. I'm in my 50s, and this was a first-time experience for me to be around people who've had a certain similar life experience as I have had. Although it wasn't intentional by the event's organizers, it quickly became clear that there was one underlying theme to all of our lives, which was identity. For instance, we learned that many of us get asked, what's it like to be a twin? And pretty consistently, we all respond, we don't know, because we don't know what it's like to not be a twin. Every identical twin experiences a variety of identity issues. The majority of us all admitted that we grew up not as two individuals, but as the twins. Many of us break free from that identity and create our own lives, and many of us embrace that identity and stay together. I was surprised, actually, how many grown twins live together to this day. I could talk about this experience all day. It was amazing, but I just wanted to share this because my belief that the concept of identity is pervasive, and I truly believe it is one of the most significant aspects of who each and every single one of us is. I was originally just going to stop there, but upon reading some of the testimony, I've decided to add a second part to my statement today. As you know from prior statements I've made within this task force, I think it's important and essential to consider opposing viewpoints seriously, and I certainly endeavor to understand them and to explore whether or not I might need to alter my viewpoint. As my kids know all too well, I've been known to change my mind. So I was excited to see that the task force had received first-time testimony from Family Equality, an LGBTQ+ rights advocacy organization, and I felt a connection with them as a gay man myself, even though I myself am unfamiliar with this specific organization. I happily learned from their letter that they were addressing the one main topic that I have indeed been working to understand over the past week. And to be specific, at our last meeting, the concept of government intrusion was brought up. This is an incredibly legitimate and a serious concern, and particularly what with today's political environment. So I wanted sincerely to really grasp if this was indeed the case with 2024 Article 9, particularly because I felt that no single compelling reason was presented at the last meeting as to why 2024 Article 9 in particular should be considered government intrusion. Perhaps the Family Equality letter could help me out. Upon reading the letter, I can state first off and unequivocally that they do not speak for the LGBTQ+ community as a whole. Though this letter basically regurgitated comments that have already been made to this task force, I've read this letter many, many times to try to grasp its objectives. I don't know if it was a lack of proofreading or thought, or that there is no valid reasoning, or maybe some kind of political motivation, but the only thing I took from this letter is that they believe 2024 Article 9 discriminates because it would not give LGBTQ+ intended parents the right to the equivalent of a one-night stand as a means for having children. So I personally call this the one-night stand defense. And to be clear, I'm not against one-night stands, but this was the only reason presented for taking away the rights of donor-conceived children. To paraphrase Family Equality's subheading for their paragraph C, one-night stands should not be compared to the selection of donor gametes. Though they may both result in pregnancy, the two are completely different. Furthermore, I have agreed wholeheartedly with many on this task force on the importance of data, and I have agreed emphatically that the USDCC needs to present stronger and more complete pieces of data with their own testimony. So I was sad that Family Equality's letter completely excluded data. Here's data that I would recommend to Family Equality to help give relevance or meaning to their one-night stand defense. 1. Data that supports that they do represent the LGBTQ+ community on this topic. 2. Data reflecting how the progeny of one-night stands feel about their anonymous conception and not knowing who their one-night stand anonymous donors are. Furthermore, to Margaret York, the writer of the letter, first off, a huge thank you for your advocacy and support of the LGBTQ+ community. In addition to providing supporting data, I would have appreciated or asked when arguing your point in future letters, please consider incorporating the following, and I note that it's too late today to provide this information. What is your personal story as a lesbian mother of 3, and what were the factors that led to your decision for the sperm used for your children? Now that you have children, have you reassessed your decisions, as I myself have as a father of 3 anonymous donor-conceived children? And 2, since you recently participated and now promote your involvement with the Massachusetts Uniform Parentage Act that the state legislature passed just last week, and you believe in the importance of learning from other states' experiences, was donor identity ever considered, and was Article 9, either version, ever discussed? And if so, what were the compelling arguments on each side of the discussion, and what was Family Equality's position on it? If it was not discussed, what were the reasons? If Family Equality is able to provide this information in the future, I promise I will consider the response and whether to revisit my own opinion on this topic. As I said last time, it's not my intent to relitigate 2024 Article 9 within our task force, but I just wanted to visit this new and serious topic at this time. All opinions on this are valid, and I know we don't all agree. But in my case, I see the current government intrusion, the one-night stand, defense arguments as failed, weak, and not even serious arguments in defense of LGBTQ+ rights and against the rights of future donor-conceived children.
Thanks, Jeff. Laurel, you should go ahead.
I don't know if Dr. Andaya, no, she has nothing to say. Okay. I kind of would like Carol to be here when I speak. Are you there, Carol? Or you just?
I'm sure.
Okay, all right. Yeah, I just had a few thoughts that I guess to wrap this up, and it's really not intended to be personal. Please don't anyone take anything personal away from this. It's really just a list of my observations about the process and what I'm taking away after all these months of listening and learning. Before we take a vote on our Birth Heritage Pig recommendation to include the 2024 Article 9 of the Uniform Law Committee.
Sorry, Laurel, to interrupt. I'm just going to say I was here the whole time. I could not get it to take me back on screen. So
yeah,
go ahead.
No, I just wanted you to hear my opening remarks. Okay, so first, I just want to note that there have been versions of the Uniform Law on Parentage introduced in the Hawaii legislature in 2018, 2019, 2020, 2021, 2022, and 2023 that address various provisions, surrogacy, paternity, expedited, and professed parentage. In 2019, 2 bills passed that addressed a Hawaii Supreme Court case regarding paternity determinations. In the 2022 version, the donor identity provisions of the 2017 Article 9 were included, but that bill did not pass. In the 2023 version introduced by the judiciary, there were no provisions related to donor identity. Thus, my question is whether donor identity is the root of the problem with this legislation, or could it be that the absence of these provisions that address donor-conceived persons' access to information is the reason why the ULP has not actually been enacted in Hawaii? Second, based upon the reports from the legal parentage and the ART surrogacy pigs, attention has been given to conforming language to existing Hawaii law and tweaking parts of the draft Uniform Law on Parentage. So to me, it sounds like we might be sending back to the legislature a substantially similar version of what they have already seen in various iterations over this past 6 years. Thus, I'm concerned that the legislature may wonder if this task force seriously considered concerns expressed in public testimony to the legislature and to this task force over the past several years. Third, as a reminder, Article 9 was updated by the Uniform Law Commission in late January of this year. I understand that the Uniform Law Commission conducted hearings and research about this issue of donor identity, and they determined that the previous 2017 version of Article 9 reflected an outdated public policy regarding donor anonymity that no longer reflected the reality of the ART industry nor the experience of donor-conceived persons. Our task force heard from testifiers that practices within the ART industry are changing, they're shifting, and they're offering identified gamete options. We also heard that the extensive use of direct-to-consumer DNA testing and online matching databases has essentially erased anonymity for many, if not most, donors. So I'm left wondering why we are questioning the decision of the Uniform Law Commission on this particular article, especially given that we have accepted the remaining provisions regarding parentage, legal parentage, excuse me, and ART surrogacy contained within the ULP in a substantially similar form that has already been adopted by the Commission. In closing, earlier this year, my husband and I visited Boston because one of our bucket list items is to visit all the presidential libraries and museums within the National Archives system. Yes, I'm a history geek, I admit it. So of course, we went to the John F. Kennedy Library. There was a quote there that I saw that was very prescient, I think, to what we've been doing. And here's the quote. "Change is the law of the land, and those who look only to the past or to the present are certain to miss the future." I will be voting today to embrace the future instead of playing catch up with the past. Thank you.
Carol, did you have anything to say before I open up to public testimony?
I think people have heard many, many times my feelings on this issue about government overreach and imposing burdens on certain members of our society we'd impose on others, and the ready availability of information and the like. So I'd rather wait for public testimony and reserve my right to respond later when we actually discuss these issues.
Sure. Brendan, do we have any hands raised?
3 hands.
Okay, first one.
Hi there. Sorry, I'm getting my camera on.
Yes, 3 minutes, go ahead.
Okay. And just to say, because I have 3 minutes, I can't respond to everything that was just said, but I will share with you what I have for 3 minutes. So I first wanted to start by saying just, thank you for receiving my comment and for allowing me to speak here today. And also just thank you for really this thoughtful dialogue on how to best protect children and families in Hawaii. My name's Meg York. I use she, her pronouns, and I'm the director of LGBTQ Family Law and Policy for Family Equality. As you heard a bit about us, right? National organization that's been advancing lived in legal equality for LGBTQ families for over 40 years. And I'm here today to share our organization's support for comprehensive parentage protections, what you are working on. Aligned with the 2017 Uniform Parentage Act. We believe that this model legislation is the most inclusive and reflective of today's families, and not just LGBTQ families, but really all families. As you know, Article 9 was recently revised, and Family Equality has deep concerns about the revision and its potential to harm all families who rely on donor gametes, including kids, right? The kids part of the family, and people who build their families with the potential infringement on reproductive liberty and privacy. So it's for those reasons primarily that we urge the task force to include the 2017 version of UPA's Article 9. I've also been asked to share the position of GLBTQ legal advocates and defenders since they can't be here at this meeting due to some conflicts. Both Family Equality and GLAAD, single A GLAAD, have worked on parentage protections in many states and believe that every child should have a parent-child relationship protected no matter how their family is formed. And we know that families are formed in so many ways, including where some parents are genetically related to their children and some parents are not. Family Equality and GLAAD both take the position that the 2017 Article 9 strikes the appropriate balance here, right? It ensures access to medical and health information, but doesn't mandate identity disclosure. The reality is that there's just more learning that needs to be done before we should cement in law requirements that are untested, that restrict reproductive options, and that exceptionalize families who use assisted reproduction as a path to family building. And like USDCC acknowledged, the trend is toward disclosing. So if this is already common practice, why do we need the government to intrude here? In addition to mandatory disclosure being worrisome in a post-Dobbs world, it's also unwarranted. And I want to remind us that Roe was our present until Dobbs became our future. Before I close out, I just want to stress the importance of comprehensive parentage laws once again. Updating parentage laws like you all are doing here is just so important for the protection of all families. And family equality really strongly supports the UPA. When it comes to Article 9,
Wrap it up,
there's
please.
option on the table that strikes a good balance in sharing pertinent information without wading into this murky territory. And so I sincerely hope that you'll consider including the 2017 version of Article 9 in your draft uniform law. So thank you.
Thank you, Brennan. You can bring in the next.
Thank you.
testifier.
Hi, everyone. My name is Jordan Wilson. I use he and him pronouns, and I'm the executive director of Collage. Thank you very much for allowing me some time just to clarify our position. I mistakenly submitted an early draft of testimony for this task force, and just want to reiterate a few things. I did submit updated testimony today, but very clearly Collage is in support of the Uniform Parentage Act. And also just to clarify, we are in support of that Parentage Act regardless of the inclusion or exclusion of Article 9. The intention was not to take a hardline position on Article 9, but rather to reiterate that we do believe anonymity is functionally impossible in this day and age. And also there are, in our opinion, some good legal reasons to have this debate. And so we encourage this discussion, look forward to more conversations, but ultimately our goal really is to pass parentage protections for children with LGBTQ plus parents, regardless of the situation with Article 9. I do also just want to point out that in the updated letter, we are responding to some testimony that we felt was really dehumanizing in terms of its language toward donor conceived people generally. Donor conceived people are a huge part of the community that we are cultivating at Collage of people who have LGBTQ plus parents, and certainly are not the only members of that community, but are a large and possibly the largest contingent to date, and certainly will be the largest contingent in the future if they're not already. And just to reiterate one final point, that it is very important, regardless of where you land on Article 9, to make it exceptionally clear that donors are not parents. Making that distinction is really part of the whole reason why we are as supportive of the Uniform Parentage Act as we are. And we think that it is critically important to underline that in whatever legislation ends up being introduced. Thank you.
Thank you. Okay. Brendan, do we have one more?
Yes, bring them in.
Great, thank you.
Good afternoon. As you all know, my name is Jamie Spears, and I am an advisor to USDCC on LGBT families. First, I want to thank the task force for your work and consideration of how best to implement the Uniform Parentage Act in Hawaii. I want to apologize to the task force for the times our testimony may have come across as dictating what Hawaii must do. Our goal has always been to share the unique needs of donor-conceived people and their families. We are working across the country to update parentage laws, not just Hawaii. One of USDCC's primary goals is achieving comprehensive parentage protections. We are seeking the introduction of the Uniform Parentage Act, including Article 7 and 9, in multiple states in the next legislative session. To properly protect donor-conceived people and their families, the law must address families formed through third-party reproduction. While some may say this exceptionalizes donor-conceived people and their family, such laws actually equalize them. For example, parentage laws must specifically provide that a donor is not a parent and how a genetic parent establishes parental rights through assisted reproduction. Donor-conceived children who are members of our community are at risk of family separation without such laws. This is one of the aspects that makes donor conception different from non-third-party assisted reproduction. Another aspect that differentiates donor conception is the fact that donor-conceived people are systematically denied access to birth heritage information by commercial entities. Thus, Article 9 equalizes donor conception by providing adult donor-conceived people with the option to access information. This is consistent with the movement that to give adult adoptees the option to access this information, which Hawaii admirably has already done. We wholeheartedly believe that strong parentage protections for donor-conceived children and allowing donor-conceived adults to access their information can and should coexist. We believe that families and donor-conceived people are best protected when Article 9 is adopted as part of comprehensive parentage protections provided in the Uniform Parentage Act. For this reason, we urge the task force to recommend Hawaii enact comprehensive parentage protections provided by the 2017 Uniform Parentage Act, including the 2024 Article 9. Thank you so much for your time.
Thanks, Jamie. Brennan, just checking, no further hands?
No other hands raised.
Okay, so discussion on testimony, Judge Hall?
I just want to clarify some of the things Laurel set out. The 2018 version, yes, the identity portion was one of a number of issues that did come up the first time the bill was introduced. That's why the initial task force was created. Unfortunately, we were not able to complete, for various reasons, including COVID, not able to complete that portion of the work of that task force. The 2022 version didn't include it because it also didn't include the art or surrogacy provisions at all. Those sections were completely removed from the bill. So it's not that we're presenting us the same thing over and over again to the legislature. In fact, it was because those sections were removed that the legislature wanted this task force to be created to see what we could do to get everything comprehensively included.
Carol?
I'm not going to say everything I've said in the past. I promise. We've had far more discussion on this issue than we've had on any other issue. And the other work of the task force is obviously very, very important. What I come back to, first of all, I'm not against donor disclosure. I do have my concerns, as I've said many times, probably partially on an emotional level as the mother of 2 children born through anonymous donors. I don't approach with complete equanimity the idea that, well, you could have had other children instead of them. It's okay if they were outlawed. I don't think you protect people by preventing them from coming to an existence, but I realize that's probably more of an emotional argument than a purely legal argument. My main thing that I keep falling back on is Hawaii is not in the habit of adopting laws that are unnecessary or have no effective impact or no meaningful impact. We do not have any anonymous donor banking going on in the state of Hawaii at this time. Dr. Fratarelli can, of course, correct me on this, but to my knowledge, there's no reason to believe there is going to be any significant anonymous donor banking going on in the state of Hawaii. Those of us who did use anonymous donors who live in the state of Hawaii got our anonymous donor gametes from other states that would not be prohibited by the law that is trying to be passed here. So essentially, we're being asked to pass an unnecessary law because people with I don't doubt, very deeply held convictions, although I don't think they represent equally both sides of the donor-born community, because I live with 2 of them, and that's not at all how they feel. But they need a win. They're trying to build momentum. They've told you this is part of a national strategy. The sooner they can get one state on board as having adopted the 2024 version of Article 9, which no state has done yet, the better they can say, look, we already got one state to adopt it. Now we need another one. Now we need another one. So there are reasons for them that is politically advantageous to get Hawaii to pass a law that is just plain not necessary right now. But is it in Hawaii's interest? Even if we agree it's not clear, we don't know what the impact it would have on single people, on infertile people, on LGBTQ plus people. We don't know for a fact. It hasn't been tested. But we're not even in a position to test it, to figure it out, because we don't even have anybody here who's doing it. So we're not going to see the effect as clearly. So why wouldn't we let other states adopt it first, see what impact it has there, see whether it does or does not create additional obstacles, and then decide if it's necessary here, as opposed to adopting it just to give somebody a notch on their belt so they can go forward and say, hey, one state has adopted it already, the rest of you should adopt it too. You know, I'm glad the culture is changing. If the culture changes so there's no such thing at any sperm bank as anonymous donors, I'm okay with that decision. But legislating it when we do not reach into the procreative decisions of parents in any other way, we don't say you may not have a child that has Down syndrome, you may not have a child that has dwarfism, you may not have a child whose parents are both alcoholics and have no money. We don't tell people which children get to come into existence in any other context, to my knowledge. But this is the one case where we're going to say the lives of these children are going to be so terrible that we're not even going to let them come into existence. I can't agree with that, especially in a context in which we have no real need for this kind of government overreach right now. If this were a huge problem in the state of Hawaii, if we had 500 people here in Hawaii saying this is awful, it would be different. But we have mostly people from outside the state who want Hawaii to set a precedent. And I don't doubt their convictions are sincere. I don't doubt their feelings are real. But that's not a reason for us to pass a law. We don't typically pass laws that don't have much applicability in our state. So for that reason, I'm totally happy if the culture changes. I'm totally happy if we revisit this law in a few years when there's more information. But right now, I don't think there's a good reason for passing this law. The 2024 version, to be clear. I will vote in favor of the 2017 version.
Deirdre?
Thank you. I have to end right around 3 o'clock, so I don't know, and I definitely would really like the chance to vote on it. So I hope we can, stay focused since we've discussed this so much. I'm not going to repeat everything I've said before. I do very much thank everybody for all of their sincerity and then telling their personal stories. That really matters to me. It's helped me to understand this issue in a way I never have before. I have extensive experience with legislation. I do not think that it's appropriate or that the legislature should consider enacting a statute that has no application within the jurisdictional reach of the state, because there are no banks that would be subject to the law. So it's enacting what would essentially be a hypothetical within the jurisdictional reach of the state. When it comes to enacting uniform laws, and I've had occasion to study this in other circumstances, Hawaii is typically not at the forefront of enacting uniform laws. We typically wait and see what happens and percolates through other states and then consider it, which is just a pragmatic thing about how we do stuff here. For me, in addition to the pragmatics of feeling like the law has no application and therefore does not need to be enacted in this state, is I very much object to the level of government interference in what are among the most intimate decisions that anyone ever makes. And so you can have a fair debate, and actually I think it would be, like I said, everyone is right. It would be correct on both sides and in good faith on every side, whether it's a good idea or not. But that doesn't mean the government should make that decision for you. So that is, how I come to it. So I would like us to include the 2017 version of Article 9 in our proposed bill, because I would like to see us address this area rather than leave it unaddressed. And I don't think that it is appropriate for the 2024 version to be enacted in Hawaii. Thank you.
Dr. Ferrelli?
Hello, and first of all, let me thank everyone for allowing me to be part of this process. I've learned a lot, and I agree with Deirdre, and I agree with Carol. I agree with everyone, really. I mean, I certainly understand both sides, but as a physician and seeing patients and seeing both donors and the intended parents, I also see both sides there as well. I think that one of the things that's mentioned a lot is losing anonymity, and that's not the same as mandating the ID disclosure. We are losing anonymity, that's true, but mandating ID disclosure is different, and that's we're going to certainly lose a donor pool who might be available if they were able to opt out, which they're able to at this point. so I do think it's, we're imposing some different treatment on patients that are going to be wanting to be parents and those who are wanting to be donors. I also think that the reality is that everyone realizes this, but not all individuals or families will align with the same position on any advocacy organization. There's always going to be people on both sides. And there are many donor-conceived individuals who do not seek donor identities, just like there are many who do. So I do think that there is going to be by mandating, donor ID disclosure, I think that there will be an effect on reproductive autonomy for both the IPs and the donors. I don't think that this should be legislated at all. As been said already, most clinics and banks are already collecting extensive donor information and giving that to the intended parents and to the donor conceived individuals. And the trends show that this is increasing and that more ID disclosures ID disclosure is becoming the norm now. And it might in the future be that everyone is a known donor. But again, I don't necessarily know that we need to legislate this at this point. And so I certainly would vote at this point for the 2017 version.
Thank you, Dr. Farabee. Other comments? Points for discussion?
Yeah, I guess I just have one thing to say. I guess I'm a little confused because if we agree with Carol's position that this law really wouldn't apply in Hawaii, then I don't know why we would do anything, because if the law is not going to apply with regard to donor identity in 2024 version, it's certainly not going to apply in the 2017 version if basically we're not doing what the two provisions say is being done. So if we're not, I mean, I'm a little confused why all of a sudden 2017 applies, but 2024 doesn't.
I can answer that if you'd like. A practical answer is, for instance, I received about, I think it was 75 pages of medical background on my donor. I would be able to submit that to the Department of Health if it were part of the law, and that would be able to be preserved in the records of the Department of Health, and it could be disclosed by the government, although why it would need to be, I don't know, because I have it. But there would be ways to at least preserve medical information and background information in the records if we wanted to, and make it available at a later date. So that would be something.
But that's not what 2017 says. It's basically supposed to be a interaction between the members of the family, not with the Department of Health involved, unless I'm confused. The interaction is between the donor and the donor conceived person. The Department of Health isn't involved unless I'm confused.
It's not mandating disclosure directly from a donor of medical information directly from a donor to a donor conceived person. Is that what you're saying?
Well, even in the 2017 version, I don't think the Department of Health is mentioned in there as the retainer of information, are they?
I don't know. I'd have to look back at the language of the statute.
Yeah, I'm pretty sure they're not, because that was one of the first things that we talked about way back months ago, even though it feels like years ago. Because I know for adoption, Carol, you mentioned that you have been complying with the law with regard to adoption and collecting information. So I know that that's there.
Yeah, I'm sorry. I don't know off the top of my head. I'd have to look back at the language of the statute. For me, it was not a non-issue because we do already do it with the collection of information adoption. And so my assumption has been submitting the same information the way I do. We submit non-identifying information when we have it sometimes already. So
for ART, is that that's fine.
Yeah, if I know a donor's, if I have in the documentation, for instance, from the sperm bank, a donor's ethnic background, I will include that in my documents for the birth certificate as part of my parentage, establishment of parentage, to make sure that we preserve that. So
and how would the child know to go to the Department of Health to get?
It's on their birth certificate. That part gets on their birth certificate, but if it's mandated by law, then the same way that adoptees know. Somebody tells them, hey, the law says you can get this information.
Okay, well, I guess I missed that. Okay. What section is that? Do you know right off?
I don't know. I'm not sure what you're asking. What section is that? What section of the adoption law says that?
Yeah.
Isn't that 578.15, Judge Hall? I think it's
Yeah.
578.15.
So you're saying the adoption law applies right now to ART? Okay.
No,
All
no,
right.
no, I'm not. No, well, I finalized
Confused.
non-genetic parents right now using the adoption statute because I have no choice because we don't have
Right.
a surrogacy statute.
Right. That's what I
But
thought.
genetic parents, I use the parentage statute.
Right. Got it. Okay.
But I try to make sure what information I submit is correct for the child in terms of their heritage.
Right. But yeah, I guess the thing is adoptees know they can go get their information, of course, if they know they're adopted, but I don't think there's any provision on law for ART kids, for donor conceived kids. That I'm
Well,
aware of.
I think Laura, you're right. And that's one of the issues I think that one of our speakers mentioned in her written testimony today is one of the big problems in this area is actually family secrecy within the family.
Right.
And nothing in the statute would legislate disclosure by parents to child.
Right.
And so if a person, in the same way that unfortunately many of the people that have testified found out about their genetic heritage late in life when all of a sudden they were told, by the way, your father's not your genetic father, which is terrible and is known to be one of the main sources of unhappiness in donor conceived people. That could still happen even with an ID disclosure. You could have an mandated ID disclosure at the age 18 and parents could not tell their children until they're 18 or older, hey, by the way, we use donor gametes and you can go look up your records.
Right.
So unfortunately, that unfortunately is not legislated. But
Well,
that would get in even more tough areas, I think.
Yeah, I think sometimes, like I said, with policy, sometimes you have to set how shall I put it, a high bar. I think we were talking about that earlier today. So people are informed early on that we don't play, hide the whatever from your children.
Yeah. But there's nothing, Judge Hall, correct me, but there's nothing in the adoption statute that requires parents to inform their children at a certain age that they're adopted. They have access, the child's allowed to access their records at 18, but if their parents don't tell them they're adopted by the age of 18, they
Right.
won't know. They could find out when they're
Well,
35.
They find out through DNA, but we've already gone over all that.
Yeah, exactly. It's tough. I'm not unsympathetic. It's a very, very tough area, and it's a mixture of parenting and ethics and legislation and a whole bunch of stuff. And the question is just where we draw the line between governmental intrusion and governmental imposition of certain standards and requirements and where we expect people to act responsibly and decently. My children, they first heard about their donor when they were under 3 years old, because that was just, I knew from the beginning to answer their questions openly and honestly.
Right. Thank you, Carol.
Thank you, Laura.
We just want to make sure we have quorum.
We do.
Okay.
We have quorum.
We've still got it, right? Does anybody else need to leave in the next few minutes?
We still have quorum at this
Okay.
moment.
Okay.
So, at this point, if there is no other discussion, I'll
think we
entertain a
should.
motion, whichever one needs to be made first.
Well, I will go ahead and make the motion that the PIG recommended, which is to adopt the 2024 version of Article 9 and voting yes.
But hold on.
Oh, sorry.
Can I get a
Oh, I need a second.
Yeah, I need a
Sorry.
second.
Sorry.
I will second that.
Thanks, Jeff. All in favor, please raise your hand.
Two.
We have Jeff and Laurel in favor. All opposed, please raise your hand. We have Geraldine, Mark, Deirdre, Sean, Dr. Fraterelli, Carol, Judge Hall, and myself opposed. Okay, so the motion fails. And there are no abstentions. Everyone's voted. I can entertain a different motion at this time, if one.
I'll make a motion that we include the 2017 version of Article 9 in the task force proposed bill.
Can I get a second?
I'll second.
Okay, all in favor, please raise your hand. Okay, so I have Deirdre, Geraldine, Carol, Judge Hall, Sean, Dr. Fraterelli, Mark, and myself voting in favor. Okay, is that 8? 1, 2, 3. Right, and then all opposed.
Me,
Mm,
I don't know about Jeff.
oh, yeah. Dr. Farrelly, can you put your hand down unless you're opposed? All right, and Laurel and Jeff opposed, although, so we had 8 in favor, and I believe that we do need 9 for it to pass. So this motion does not pass either. I'm going to have to, Deirdre, you're on mute.
Oh, sorry, did somebody not vote? I thought everybody voted. The math doesn't add up.
Everybody voted.
Oh, okay.
You need a,
It's,
I need 9.
you need
I
9
need
to,
9 for it to pass.
it's not the majority of the people who are here.
No, it's the majority of the
task
task
force.
force. That's my understanding.
Thank the sunshine law.
So I'm going to table this because I do think we will not get a different vote. We can put a new motion up, then we will not get a different vote with the people we have here today. We'll probably have to reschedule another meeting to kind of discuss this and consider how to go forward. Probably ideally with additional members of the task force involved. I would like to kind of just put out there for the task force to consider that we do include, because this has been very split and there's, as we've all mentioned, kind of good viewpoints on both sides, that we do include mention of either, whichever article it does not get included in the task force final recommended draft, and reasons though that particular article was not included, and some considerations for why that might be included.
I was assuming we were gonna do that, like there would be a minority report or whatever you call it. I mean, I thought
Yeah.
we were definitely doing that. Yeah.
I am just, I'm putting it out there and making it clear that I think that that's something particularly in this area that would be valuable to the legislature, regardless of which article eventually ends up in the draft. But with the attendance that we have, we will not get a majority vote today. So we will have to reschedule. We will have to schedule another meeting. I do
Are we
need,
still able to move forward with creating a drafting pig and at least getting started on the things we voted on?
yeah, so I was just about to move to our last item on the agenda, which is to create our drafting pig. And the task force has voted on 2 of the 3 areas that we've started on. So the drafting pig can get started. So I'm creating a permitted action group to begin the draft of the task force final report. Deidre, can you mute? Just, thanks.
I was looking at chapter 92.
Yeah,
It's 92.
I'm creating a permitted action group to begin the draft of the task force final report and propose legislation to give effect to the policy choices that have been or will be accepted by the task force. The drafting pig can decide amongst themselves when to meet and how to divide up their tasks. And each member of the pig will have the full scope of authority of the group itself. And the members of the task force will be myself, Lauren Chun, Judge Hall, Deirdre Maria Iha, Carol Lockwood, Laurel Johnston, and Geraldine Hasegawa. Have any comments, discussion on this? Okay, Brandon, do we have any public testimony on this matter?
No hands raised.
Okay, great. So those are all the items on our agenda. We'll have to follow up.
Don't we have to agree to establish the pig?
No, the chair can establish the pig
Okay.
for itself. So, does anybody object to establishing the pig? Okay.
No, I just wanted to make sure if we needed a vote that we had one. So,
No, yeah, thanks. We don't, yeah, the chair can establish the pig themselves. Okay, so that's all that's on our agenda. We will have to create a new meeting, so I'm sure Derek will circulate a request so that we can resolve the birth heritage issue.
I have one request, separate from that. For the portions of the bill that would include the definition sections that we voted on today, I would like to ask that someone at the AG's office put them together, keep all of the redlining and the comments and put them into bill format, because right now it's not in bill format. There's that, that thing with the numbers on the left-hand side, a bill for an act, blah, blah, blah. That would be great. We can start with that. And then regardless of what happens with the birth heritage portion, we can just start with the first article.
Yeah, Deidre, so the drafting pig can discuss kind of next steps between themselves.
I just thought it was a good request to do it now, since it's just pasting together 2 Word documents and putting it in the format, so.
Yeah,
Yeah.
perfect. But be on the lookout. We'll have to schedule another meeting so that we can resolve the birth heritage issue. Although we don't need any new reports, I think the task force has all the information it needs, and it just needs further discussion and more participation from the task force members. So with that, I'm going to adjourn the meeting at 2:47. Thank you all for your time and careful attention.
Thank you, everybody. Have a good weekend. Bye.